Okay. Excellent. Thank you. We have a comment here in the live stream. This is an excellent question. I love this question. She says, I have over 50. So she's preparing for trial and she has all these exhibits. I have over 50 exhibits for my trial hearing. I need to mark my exhibits per trial rules as respondent A, B, C, etc., using the letters of the alphabet rather than numbers. And the reason why this is because typically the petitioner or the plaintiff in a case usually marks their exhibits with numbers, and the respondent or defendant typically marks their exhibits with letters. And so she's right. How do I do this with only 27 letters in the alphabet when I have more than 27, when she has 50 exhibits? What does she mark them? Once she gets to Z, what does she do after that?
There's a few different ways to do this. You could just take out a Sharpie and write AA, BB, CC. It's probably the easiest.
That's what I do. You double up on the letter.
And you're not going to find pre-printed forms that say that. And so, just do them by hand. Hopefully you have good handwriting.
And then if you get to ZZ and you have more exhibits, then you go to AAA. That's what I do. Is that what you do?
I usually don't get to more than 50 exhibits, but certainly could.
Yeah.
Yeah, of course,
use a marker.
The judge can always order something else. Like I have a case right now where petitioner gets, all the exhibits are going to be numbered, and the petitioner gets 1 through 200, and the respondent gets 201 through 400. And there was no indication of what we should do if we have more than 200 exhibits.
That's a really great comment. What you can do is call the court clerk in that department where your hearing is going to be, or go to the courtroom and ask the clerk what that judge likes to do if the clerk knows. And the clerk might have stickers. You can say, do you have any exhibit stickers that you can give me? I have 50 exhibits. And they may have stickers for you to put on pieces of paper to mark exhibits. And she might, or he might tell you, here's what the judge wants you to do, A1 or whatever. So that's a great question. She says, I need to amend my exhibit list and exchange it at least 20 days before trial. Does my amended exhibit list need to be served with proof of service filed? Good question.
Yeah. Yes.
And why is that the case?
Why you always do. Anything that you give to the court gets served on both sides. And so you always serve it on the other side. And it's always a good idea to have a proof of service. If the other side is represented by an attorney, they're probably not going to make a big deal about not receiving documents, but you never know. And so always file your proof of service in case something gets lost or they claim they didn't get it. I never had problems with opposing counsel not receiving documents at some point. Usually what happens before a hearing, if they haven't received the documents, you'll get a phone call and they say, hey, I never got anything here. And you go, oh, well, I mailed it or I emailed it on this date. And then they either find it or you make arrangements to get them another copy quickly. But it's a good idea to get a proof of service saying that you sent it over. And the next question, can service be by email? Usually, yes. If you've ever exchanged documents with the other side by email, then the answer is yes. If not, a phone call to the other side, and usually they're going to say yes because it makes it easier for both sides. But when it comes to exhibits, maybe not. It might be easier to print everything out on paper and walk them over. If you have 500 pages of exhibits, email might not be easier for you. It might be more difficult. It just depends on your circumstances.